thank you everybody for jumping on. We have people getting on. We have a good crowd here. And my name is Paul Hitchcock with Barth Calderon. And for those of you who don't know our firm, we're an asset protection, estate planning, and business planning firm. We've got a tax planning focus as well, with about 4,000 clients across the country, located in Orange County, California. And honored to have four really great guests here. I'm going to introduce them right after I mention a couple of things here. One is we are recording this broadcast. This is our channel called Wealth Protector TV. So everybody that registers, we're going to send out a copy of the video afterwards. Give us about 3 days to edit that, and you'll receive that via email. Also, we offer a complimentary assessment with anybody on these panels for those in attendance. So you may have some questions that we can't get to on this event, or you may think of something later on. But these are four really great experts. So that will be in the email that you get as a follow-up on how to schedule that assessment with any of the experts here. And then you'll also get a notice to subscribe to our YouTube channel. So look for that as a follow-up, because we put a continuing amount of short snack size videos on our YouTube channel from experts like the ones you're going to hear from today. And they're great. We load them up every week, and they're on high impact topics that affect you, your business, your planning. So be sure to subscribe to that channel when you get that email. Now to our guests. I've got a couple of my colleagues at Barth Calderon with us. Our founder, Harry Barth, is with us, also our senior managing partner. And Harry's been around the block a few times and speaks across the country on issues just like this. His focus will be on asset protection, the liability side of things. So we're honored to have Harry here with us. Also have my other colleague, David Calderon, who is one of our expert attorneys at the firm, and runs our disputes practice focus, in addition to being an expert in asset protection and business planning. Steve Williams is with us, and Steve is a founding partner of Freed and Williams, which is a landlord representation firm in the Bay Area. And Steve is an alliance member with our firm, so very close relationship there. And then Tim Kolatz is with Hub International. Tim is an expert all things insurance, property, casualty, and beyond. And so thank you everybody for joining. And the way we're going to run this is we're just going to get a little bit down and dirty here. We're going to start off by with Harry. And I want everyone, start with Harry, then David, then Steve, then Tim, to give a kind of a 2-minute overview of what's going on. Harry, obviously asset protection liability. And then I have some questions that have been emailed in. We're going to get to those. We'll open it up for live Q&A. And if there's interaction between the guests back and forth, fantastic. Let's just let it roll. So Harry, take it away.
Oh, well, thank you. It's good to be here with everybody. And it's a really a historic time. And one of the things that we think about, even when we're not facing a pandemic that we're having right now, with this COVID-19, is build the assets that we currently have. We've worked very, very hard to maintain the assets that we have, our businesses, our real estate, our homes, our bank accounts, our retirement plans, our 529 plans, inherited assets. We've worked very hard. And always, not just now, but always, we should always make sure that if we are the guardians of our wealth, that we have built fences and walls around that wealth to make sure that, God forbid, we're hit with lawsuits or potential liabilities, that we have the best chance to settle that, settle it within the insurance limits, which are a very, very important part of asset protection that Tim's going to be talking about. But to level the playing field, because I've come to the conclusion over the years, and it's gotten worse as time's gone by, that if we have any assets, we have any wealth, the playing field is not quite level. I've never heard of contingency fee, defense attorneys it seems to be in favor of the person, the plaintiff, that is suing someone that happens to have some assets. Of course, nobody wants to sue anybody that doesn't have any assets. There's no sense in doing that. So I think that it's very important that we understand that. What's happening now? Well, what's happening now is how can I best say it, a great cone of uncertainty. We have no idea how much litigation and liability is anticipated to come as a result of this pandemic. Employee-related liability, landlord-tenant-related liability, contractual liability, and for many people who can't make their rent payments on time, who can't turn around and meet some liabilities, significant amounts of personal guarantees that could be called. And we're getting clients who are calling us quite a bit now saying, well, everything is okay at the moment, but we're not so sure 3-4 months from now. We have a large building, we have a large loan, we have personal guarantees on that, and am I going to lose my home? And you know, a lot of it's unanswered, but I can tell you that we're anticipating a surge of litigation to answer the unanswered questions that come as a result of this pandemic. And that's my 2 cents to get started. I think that we're in historic times, and we should all be taking a look at our estate planning documents and reviewing all of our assets from an asset protection perspective to make sure our fortress is as well built as it possibly can be. Paul?
Great. Harry, thanks so much. David, can you jump in, tell us a little bit about your focus and some of the things that are going on now?
Yeah, a lot of my focus has to deal with disputed matters and issues that could possibly end up in litigation, or issues that are already end up in litigation. I also do a lot of transactional work for people to help protect their assets, prepare their contracts correctly, and negotiate deals. And part of the problem we have right now is there's just so much fear out there, and fear bred from uncertainty. People just do not know what the new normal is going to look like. And Harry touched upon it, that right now, there are a lot of people that are doing okay, but a month, 2 months, 3 months down the road will not be doing so okay. It's almost like throwing a rock into a pond and you get a ripple effect with all of these issues. And some of the issues just keep getting bigger and bigger. I mean, people are making deals right now to forbear debt or to defer payments. And quite frankly, a few months down the road, circumstances may change. They may not be able to fulfill those deals or those contracts. And therefore, like Harry said, there's going to be a lot of litigation that comes out of this. There's going to be a lot of bankruptcy, probably, unfortunately, that comes from this. And I've been fielding calls. I had one 9:30 Saturday night. I got a call from a client who was worried and scared and wanted to talk through a lot of the possibilities and things that could happen, wanted advice on which way they should go. And it's a tough time. And hopefully professionals like the people that are on this webinar can help provide at least some sort of certainty, or at least help you navigate what are really, really uncharted waters.
Great. Great. Thanks for that. Steve, what about your area? Quick introduction, as we move into some more detail.
Yeah, thanks, Paul. So I represent property owners and landlords. And I'm glad to be on this panel here with Harry, David, and Tim, because part of my practice is educating clients of the importance of asset protection, and also insurance, which is a large part of that asset protection. And I tell my clients, out of the gate, before I step in and roll up my sleeves and begin to represent them regarding a landlord-tenant matter, that they need to have, at a minimum, insurance in place that protects them against personal injury, wrongful eviction type claims from tenants. That being said, what I'm fielding now are questions, daily from clients. Hey, my tenant can't pay the rent this month or last month or next month. They've lost their job. However, they may have been impacted by the coronavirus. And the important thing to note is there are several different layers of laws that are in play right now that are essentially putting moratoriums on certain types of evictions, and specifically non-payment of rent evictions. It's at the state level. There's a governor's order. At the California courts have also placed orders basically staying unlawful detainer actions from proceeding through the court system. There's also local orders. Virtually, every major city in California has some form of a local order, emergency order, protecting tenants who cannot pay rent. And those vary from city to city, but primarily there are basically they're affecting delays in the ability to collect or recover the rent, and also implementing repayment plans up to, I've seen them up to as high as 12 months. And then there's also, believe it or not, there's actually a federal ordinance or moratorium in place as well for certain types of federally subsidized property as well. So right now, there's just not a lot going on in terms of pushing any sorts of evictions through the court system, and everything's sort of on hold right now, pending further changes in the existing orders.
Great intro. Tim, what's going on in your insurance world there?
Thanks, Paul. I appreciate it. Tim Kolotz with Hub International, all things property and casualty, like you said, Paul. Right now, the big things that are coming across, as Steve touched on and so did Harry, is you're looking at business owners that may be a tenant in a building. So you've got a building owner that leases the tenant to the business owner, and they're worried about if they're closed down, do they still have to pay the rent, things like that. We're working with our clients to discuss if they do own the building or not own the building, how they're able to function and pay those bills, and working with the landlords to get some kind of rent relief if it's needed. On our side, we're also always looking at the future. So as Harry touched on, we don't know what this thing's going to look like in 6 months. But a lot of my clients are of the mindset that, hey, we may not be at 100% of our normal, but we need to be protecting ourselves as we're moving forward here. And how are we going to do that? Both from a business point of view, from an employee point of view, and a potential later on down the road exit strategy point of view. So when we're talking about stuff, as David talked about, we're not looking at 3 months, 6 months down the road. We're looking at 18 months, 24 months down the road, making sure that people have got their assets in line from an insurance point of view, from a protection of both being sued by either an outside person or from their employees. So that's kind of where we're headed right now, is we're talking with our clients about not only the current state, but also the future.
Nice. Okay. So I've got questions here. I'm going to jump around, no particular order, as I go through these. Harry, I want to start with you because we've gotten several questions on this, and I know the firm has dealt with this issue also. Is a business owner who has personal guarantees, and so the business is either shut down or is flailing around, and they have personal assets that are backing the personal guarantees. We've seen this in the restaurant business, franchisees. So the question centers around liability. How would that play out? I mean, if they can't, if they start going under and the business is done, what's the asset protection issue there when you're backing things with your personal assets like that?
Oh, really good question. And of course, the question that we're now getting 10 times a day. Because people are concerned, they have the guarantees, they're required to put the guaranteed in order to lease the spaces that they have, guaranteed on loans, a whole cornucopia of guarantees. And a lot of people don't quite understand how they work. So let's just take step by step and then what can be done about some of them. So the first thing that people think is, well, does the creditor, if we have a personal guarantee, for example, on a business line of credit that's been buying inventory in the business. So the question is does the creditor, and we're in default and it's a $3 million guarantee. So the question is, does the creditor need to liquidate and go after the business assets first before they go after the personal assets that they have? And the answer is relatively simple. creditor does not have to even deal with the business. Once they defaulted on the loan, they can immediately proceed after your personal assets, and in order to satisfy the guarantee. And then one of the questions that come up all the time, that it's just typical, is that, can they go after my house? Can they take my house away? Will we lose our home? This is a very, very big question. And although it's a state by state exemption amount, so for example, in Texas or Florida or Kansas, you would never lose your home to the claims of a creditor. It's unconstitutional in those states. Let's just pick on California for a second. So California says that if you have more than $75,000 of equity in the home and you're single, or $100,000 more of equity if you are married or there are 2 or more people occupying the home, and $175,000 of equity if you're over age 65 or have a disabled person living in the home. If you have more equity than that, then the creditor can force sell your house, give you a check for the exemption amount, and it's gone. And people ask me, I mean, and I speak around the country and around the state, and I'll say, by a show of hands, tell me how many people think that you would lose your home or keep your home. And amazingly, most people, even in California, will say, oh, we have a homestead exemption, we keep our house. So that's a classic example of a lack of information. So I would think that one of the things that we need to do when we're dealing with personal guarantees is, I can't stop the guarantee. The guarantee is contractual. I don't know whether there's going to be some unprecedented litigation or cases as a result of the pandemic, but assuming that your guarantee gets pulled, we now look at the broad spectrum of all the assets that you have, and Tim will tell you, there's no insurance for this part, and now we need to turn around and see, how are they protected? So if we have most of the personal assets protected as much as possible under the law, I think you have a very good chance of settling or having a much better outcome on that personal guarantee. And also anticipating at this point in time that those guarantees may not be in default, it might be a very, very opportune time to take a look at that.
Got it. Okay. Awesome. Awesome. Steve, I got a question here for you, and this was sent in. I'm reading it here on my phone. My family owns a rental house. This is in California. Tenants have never paid rent on time, and it's been a struggle with them. And the lease agreement states that the lease can be terminated with written notice at least 30 days before expiration of the lease. So here's the question. Are there any regulations in the governor's executive order or the judicial council's emergency rules that prohibits us from sending our tenant a notice of lease non-renewal? And if they refuse to vacate by a certain date, can we start the eviction proceedings? Or is it possible to start the eviction process now with a 3-day notice to pay or quit? So
Yeah.
Is that enough for you?
That's a lot. Yeah, it's a handful. First, no, there's nothing in the governor's order or in the judicial, got tongue-tied there, the judicial order either that preclude the termination of a tenancy in that particular circumstance where the lease expires and you're just going to give a notice. However, there is in California statewide eviction control, and you cannot terminate a tenancy without just cause. And simply a lease expiring is not just cause. So that particular law may preclude you from terminating that particular tenancy in that manner. Now, it sounds to me from what Paul read is that this is probably a single family home. And if that's the case, then that is one of the exemptions from the state law eviction control law that was just passed. That was just January of this year. So if it is single family home and it is not owned by a corporation or an LLC that has a corporation as a member or a real estate investment trust, then it is exempt from that law and would allow you to evict at the end of the term like you're contemplating. And only so long as you have made a written disclosure to your tenant prior to July 1st that the property is exempt from the new state law because it's a single family home. So that's just the answer to that first part of the question. The answer to the second part is, while you can go ahead and give the termination notice, you're probably not going to get anywhere in the courts anytime soon. There is basically a moratorium in the court system on unlawful detainer actions, which is basically saying if you file your eviction lawsuit, the court will not issue a summons, which is how you get jurisdiction over a tenant, is by serving a summons on the tenant to appear in court. And the court is not issuing summons on unlawful detainer actions for up to 90 days after the governor declares the state of emergency order over. So right now, you could get the process going, but you're probably not going to get anywhere in the court system anytime soon. I'm telling clients, you're probably not looking really until the early part of 2021. In reality, it very well could be that long before you're actually in court in an unlawful detainer action. With regard to non-payment of rent, you're not going to get anywhere with trying to evict the tenant for non-payment of rent right now. And then the final thing to look at is, does your specific city have any additional moratoriums or restrictions that might apply to your situation? And I just don't know that offhand. But to answer your question, yes, you can proceed with a general 30 or 60 or 90-day notice that's not non-payment of rent. You're just probably not going to get anywhere in the court system anytime soon.
Got it. Okay. Fantastic. Thanks, Steve. David, question for you, and you may smile a bit because I know this is coming up a lot, is the force majeure issue, or they call it the act of God clause in contracts. Yeah. And, I know all of our experts at the firm have been taking a lot of questions about, can I break a contract? So what is going on with that whole scenario in contracts, and what are the pitfalls?
Well, force majeure, before all this happened, is like one of those things that ends up like terms and conditions, right? Almost stuff that a lot of people just seem to gloss over and ignore, that show up as boilerplate at the end of a contract where you have all these miscellaneous provisions. Not so much anymore. People are definitely now from this point forward, going to pay attention to what the force majeure clause says. And basically, force majeure, if it's invoked by either party to a contract, if it's like a two-party contract, serves to terminate the deal. So there are pitfalls and ramifications regarding force majeure. And probably what I would do is, if you have a situation where you think a force majeure clause may be invoked, is use it as an opportunity or an invitation to try to maybe negotiate new terms, or to do something rather than to try to necessarily force it through unless you absolutely have to. And whether or not you can use it, obviously it has to be a clause in the contract. So if you don't have a force majeure in your deal, unless it's a contract that's covered by the Uniform Commercial Code, like for the sale of goods, where you could possibly use like frustration of purpose or impracticability or one of those things, it's very difficult to invoke unless it's specifically in there. And a lot of people, they may have act of God language, terrorism, war, things of that nature. Also maybe state and government regulations that make it impossible for the contract to be fulfilled. It's also in a lot of force majeure situations. Not so sure about pandemics, but in the future I can guarantee that pandemics, words like shelter at home or shelter in place are going to be a part of those, or people are going to want to discuss those. So it really all depends on the scenario that you have. And the first thing to do is to look at your contracts and see, if you have a written contract, do you have that language in there? And then have a professional, talk to a professional about sitting down and evaluating the same, finding out what the best strategy is that you can put in place to decide how you want to use it, from renegotiation all the way up to termination of a deal if you have to.
Got it. Great. Thanks, David. Tim, question for you. And I think a lot of people are really thinking about this and their relationship with their insurance provider, like you. And, there may be new forms of liability right now. Certainly there's, the virus. Restaurants are another great example where they're shut down and owners are questioning their insurance providers about, am I covered? So when do you step in with clients, and how should people be interacting with you, an expert like you?
So as this started going on, and I typically am talking to my clients on average, most clients I'm talking with at least once a month. Some clients I talk with, or at least touch on a daily basis, depending on their needs. But when this first started going down, I immediately sent out a quick note and then called all of my clients to follow up with them and understand where they were headed. Were they going to be an essential business and stay working, or were they going to be shut down right away? And then we started having discussions about what we could do if they were going to be having a downturn in business, 15, 20%. So you're hearing a lot of things on the TV and the radio right now about, hey, we're giving back $2 billion to all of our clients because basically they are forced to by the laws that they're governed by. A company like Liberty Mutual, for example, is governed by their mutual status. So a company like Liberty is actually owned by their policyholders, and the federal government and the state governments actually have enforced a play that says you can't earn more than a specific percentage of premium as net profits. So you're forced to rebate back. So I personally have USAA as my insurance carrier. Every year we get a dividend back because they're forced into not earning a bigger profit. So while that's great for some of the people that didn't do it, all of my clients and I were on the front end of this, and we reduced my clients' premiums on the front end of this by about 15 or 20% because we knew we were going to have a 15 or 20% downtick in sales. On top of that, we talked about to one of my restaurants what it was going to happen. And he said, hey, we're closed for 90 days at a minimum. I need two things. One, I need to not pay for 90 days. And on top of that, I need to pay, 40% less, 35% less, because I'm going to be out of work. Because not only is he going to be closed for 90 days, but then it's going to take him another probably 60 days to ramp back up. So that's what we've been talking about with all of our clients. In addition to that, now they're worried about getting paid by their customers, right? So we've been talking to them about credit insurance, about getting that on the front end. We've already quoted 3 different clients new pieces of credit insurance that they're going to buy. So being on top of this, ahead of the game, as we typically are trying to be on a day-to-day basis, was really beneficial to a lot of people.
Yeah. So, and it sounds like the key there is it's not an adversarial relationship with the insurance company. It's a partnership. And if they're working with you, there's some solutions out there.
100%. You gotta like your broker. You gotta like your carrier. And if you don't, get rid of them. I'll be the first one to say I'm not everybody's cup of tea, right? But at the end of the day, my goal is to keep you in business no matter what. That's the first thing they teach in business school is to stay in business. The first thing that I'm here to do is to protect you. So you may not do business with me today, but in a couple of years when you do need somebody, or your guy retires or they retire or they just say, bag this, I'm done here.
Yeah.
You have somebody on the backside that understands your business and can help you out.
Okay. Fantastic. I'm just going to keep rolling here with questions from attendees as I read off the screen. In California, and this may be, Harry, this may be for you, David, you might want to step in too, but in California, can the creditor force the homeowner to draw from their home equity credit line to pay their debt?
Okay, let me deal with that one. That's a very, very good question. Matter of fact, I was dealing with that one with a client yesterday. It appears that the answer to that is no. There's no case law where a court has forced someone to proactively draw down on a line of credit in order to pay judgment. However, there's a judgment, so the court can sell the asset. So, so the answer to the question is that there is not one. There was one case in New Jersey that didn't go very well, but I have not yet seen a scenario where a court has ordered someone to take their line of credit. Dave, you may want to jump in on that.
Yeah, I've never seen that. Was that from? I wonder if that was from Pete Tentler, because I think we had that very conversation in a meeting, a Zoom meeting that we had the other day. And yeah, I've never seen a case where that has happened, where someone is like, forced you to like walk to your ATM, stick in the card, pull out money, or draw into a line of credit. But as Harry said, they can't foreclose on your house. And if they do foreclose on your house, normally what would happen is there would be a foreclosure sale, and then the creditors would have first right to the proceeds to satisfy their debts. If there's anything left over in equity after that, then that money would go to you. But in most cases, those foreclosure sales are incredibly distressed, so your house is not going to get full value. And there's likely not going to be enough there may not even be enough to go around as far as the creditors.
Yeah, and that's why, David, it's very important to build the best asset protection structures that we can around your home. I mean, it's critically important to do that, as well as around your stocks, bonds, and cash, your businesses, and your other assets. You got to build a fortress at this time, and the walls never, ever had to be stronger than at this moment. Go ahead, Paul.
That's interesting. So I got a questions coming in on the stocks, bonds, and cash, but let me get to these in order here. Hello, team. I'm in California. I have 24 seller financed homes. I am the bank. 3 families paid less than half of their mortgage in April, and it's getting worse in May. I need a private lender forbearance program and how to handle each property regarding interest and late fees due. I think these people try to dribble a few $100s each month. I just add balance, but okay. So this gets into, I guess, tenants not paying, and how bad can this get? And so I don't know, maybe Steve, you want to address what a landlord should be doing now with those tenants to avoid it getting worse, and what happens when it gets worse? Does it go to people start, is it litigation? But you want to address that real quick?
Sure. Well, it sounds to me more like this is a purchaser, not a landlord-tenant type matter, but a buyer of the property is now the owner, but they're being financed. Their lender was the prior owner, the seller.
Right.
So those circumstances are going to be a little different. If it was the traditional landlord-tenant type scenario, then what I'm telling all my clients at this point, as I explained earlier, how you're basically at a standstill with all the moratoriums and court stays and delays, is you need to really roll up your sleeves and try to work something out with the tenant. And I guess in this particular scenario, the same thing would probably apply with the owner occupier of that particular property. But to try to work out some sort of like a deferment or a forbearance agreement with the tenant or the occupant, and a lot of those may be controlled by local jurisdictions. Like in San Francisco, for instance, a tenant has up to 6 months to repay rent that they could not pay during the COVID emergency orders. In some jurisdictions, I've seen it as high as a year, like I said earlier. So trying to come up with some sort of a repayment plan for the rent that the tenant can't pay, and then to try to actually get the tenant to sign some document to memorialize that if possible. And that is particularly important in rent-controlled jurisdictions. Now, virtually all of California is now rent and eviction controlled, but specifically rent-controlled areas where there's local rent control boards that oversee these things, and basically where the local rent and eviction controls are. It's a good idea to get those forbearance or deferment agreements in writing, and never, if at all possible, agree to temporarily reduce the amount that's owed. You don't want to reduce the balance that's owed. Instead, you want to defer it. So basically push it out to a later date. So I'm telling clients, if at all possible, avoid the reduction and try to work with the tenant on a deferment or a repayment plan.
Got it. And Tim, I noticed you answered a question here that came in over the chat, and I'll just read it for everyone. What is credit insurance, and can you really get it after the fact here?
Well, the credit insurance is accounts receivable insurance. So when you provide a good or a service to your customer and they end up not paying, how do you get paid? Do you just write that off or what have you? Well, you can buy a product and you can get it from, some of the carriers that you may have heard from before, like Coface and a couple of other ones. And what these guys do is they will actually review your books, figure out what you are currently on 30, 90, 60-day terms with your clients, things like that, and then actually underwrite against your customer's credit worthiness. And these credit insurance companies will review, the top 1,000 or top 1,500 clients across the nation, across the world on a daily basis. And then they will specifically underwrite your specific clientele as well. Getting it after the fact, if you're able to get the insurance today, if that client goes out of business tomorrow or doesn't repay you, doesn't decide to pay you tomorrow, you get paid on those numbers. The insurance market is tightening up right now a little bit, but if you've got some decent clients and then a couple of crummy ones, they will underwrite your entire book of receivables and then insure you based on that entire book, not just on one or two clients. They actually don't want to insure one or two clients. They actually do want to insure all of your receivables. So if on a monthly basis, you've got, even 50 or 100 grand or as much as 3 or 4 million, they're going to underwrite that entire book.
Interesting. Okay. Question, can the government really interfere in a contract to the extent that they're giving tenants the right to pay back rent over X months? What if the lease expires prior to the time the government is giving the tenant the time to pay back rent?
Yeah, so in short, yeah, the government has powers to invoke these emergency orders, and one thing as well that you need to be aware of is that when an emergency order is declared by any government entity, certain limitations come into play. Like, for instance, in addition to these additional orders on requiring landlords and tenants to try to work out non-payment rent matters and allowing the tenant to defer it, there's some anti-price gouging laws that are implicated as well by emergency orders, and those do implicate the landlord and tenant area in that they prohibit rent increases that exceed 10%. So if you were looking to do some sort of a rent increase at this point, you're probably not advised to do so if it's going to exceed 10%. Similarly, if you give like, for instance, one of the the members earlier asked a question, well, yeah, I want to terminate this tenancy at the end of the term, which is, let's just say it's June, and if the emergency order is still in place at that point, which, like I said, you could still give that sort of a termination. Let's say the tenant moves out, you can't then charge the new tenant moving in more than 10% of what, above what the prior tenant was paying. Again, that's part of the anti-price gouging laws. So in short, yeah, the government has pretty broad authority to, put these sort of temporary emergency moratoriums and restrictions in place. And again, they're supposed to be temporary, but, that being said, I don't, I've seen them extended multiple times in different jurisdictions, and there really is no real end in sight as far as I can tell. But yes, as far as as you know, we've seen that the government does have the authority to pass these temporary moratoriums.
Okay. Case study question here, and this gets to the stocks, bonds, and cash. So, business owner, the business is not doing so well, and they've got quite a bit of money in a brokerage account, north of $1 million, and the same business owner also owns rental income property, and the tenants aren't paying. It's starting to get frothy over there, and so this is their asset base. The business isn't doing so well. They've got rental property, and then they've got, you know, north of $1 million in stocks, bonds, and cash, and that stocks, bonds, and cash is sitting in their living trust. And so the question came up with the firm the other day is what should I be doing with that, you know, $1.5 million in cash as these other things around me are kind of going south? Is what can happen there? What should they be doing and thinking about? Harry, is that you, David?
Looks like Harry might be frozen there.
Oh, Harry, you there?
Yeah, I was frozen, so I only caught a little bit of the question. Let me see if I can repeat it. I couldn't hear a thing, Paul. So I was saying that I got $1 million worth of cash. Is that $1 million worth of cash inside my business now, Paul, or is that $1 million of cash outside my business?
Outside the business at a brokerage account.
Okay, so I think it's really important, whether it be $1 million, $10 million, $500,000, that's sitting in a brokerage account in a living revocable trust, that we need to put a wall around that. At a minimum, let's build a capital holdings limited liability company member in a good section, and let's have, you know, like Harry Capital Holdings hold $1 million. I think that's really important, because right now, if a liability comes to Harry, it's direct to Harry. Harry owns the business. I mean, the account. It makes it easy for creditor. I'd like to put a wall around that. I mean, hopefully, not after an event occurs.
Yeah. Harry, you're frozen there.
Yeah, you know, if it's in your living trust, it's vulnerable, and it's
Our ability to reach inside and touch that money.
Oh, Harry, you're kind of freezing up there with your connection.
Okay, I'm hopefully I'll be back again here. So anyway, back if I'm back now, again, we're recommending at least an LLC to hold stocks, bonds, and cash, and even better, perhaps a domestic asset protection trust to hold that LLC, to put the best wall around that low-hanging fruit of stocks, bonds, and cash. And I think that all needs to be done before any liabilities are specifically taken.
What if the cash is in the business?
Well, if the cash is in the business, we have to do an examination. A lot of people are accumulating, for some reason or other, cash in the business. And that to me, whether we have a pandemic or not a pandemic, is not necessarily a great idea. That's where we have employees. That's where we have liabilities. That we have risk. It's probably the hottest spot that they have in their entire portfolio of assets is the business. So I think in the business, they should be holding no more than amount that's required for reasonable working capital. And they should, especially if it's an S corporation or LLC or pass-through entity, remove the excess capital, hold that in a separate entity. And then should the business need working capital greater than what they had, that entity, Harry Holdings, could lend back to the business the amount of money that they need for acquisitions and or working capital, and perhaps even take a secured interest in the receivables to gain some asset protection. We see that all the time. That is a terrible error. That should be changed.
Yep, got it. Okay. And David, just expanding on that a bit, what about if there's two partners in a business, they have an agreement, maybe they have a buy-sell agreement, and the business is hurting right now, maybe not sure about the viability or the other challenges. How do those multiple owners interact with each other, and how does that contract buy-sells come into play?
Well, a buy-sell contract would usually come into play if, say, the one partner wants to get out and sell. sell to a third party. They may have a provision, hopefully, that forces them to sell to the other partner first before they put it out on the open market. Usually those types of situations are invoked in buy-sell agreements for like death, divorce, disability, things of that nature. But if one person wants to bail, hopefully it provides at least a minimum groundwork for the partners to work out a deal where one partner could possibly leave and the other partner could take over the business at somewhat of a fixed price if the valuations are up to date and things of that nature, and avoid litigation, almost kind of like buy-sell agreement is almost like a post-nup for business owners. It enables them to dictate the terms of their exit prior to that exit event happening. So it's always a good thing to have in place. If you don't have one, you really should think about putting one in place.
But not related to the business having problems now, that agreement, there's separate partnership agreements and so forth for that?
Correct. Well, if the business is not going so well now, that's usually not an area that is covered by a buy-sell arrangement. However, if there's an economic strain and there's capital calls or things that need to be done, and one partner can't meet the financial obligations of the business and wants to bail, then a buy-sell agreement might provide a good framework for that other partner to get out of the business.
Got it. Okay. I think, Steve, I think this is you. What are the real chances of, let me just hear, of California AB 828 passing, where landlords are required to reduce rents by 25%? And they're asking, is there some detail you can give about that?
He's on mute.
You're on, oh, Steve, I can't hear you. All right,
Yeah, I don't.
go. You were muted. Sorry.
Oh, sorry about that. I don't put anything past the legislature these days, but at least from what I'm hearing is that it doesn't have a lot of traction. That being said, you never know. So it is something to at least be aware of and possibly concerned about. But just in short, it basically is some proposed legislation to limit eviction, basically non-payment rent evictions. That's the thrust of it. And the part that the member was asking about is basically, let's say someone doesn't pay the rent during these tough times. If following an unlawful detainer action for non-payment of rent, the tenant can establish that the tenant is unable to pay that rent due to COVID-19 related reasons, then the court has the authority to issue an order allowing the tenant to stay in possession and require that the landlord reduce the rent over the next 12 months by 25%. And in the meantime, the tenant would then repay the outstanding rent over a period of time as well. So there's a couple aspects to that. One, you have to be all the way to the point where you're in an unlawful detainer action for that to kick in. Two, the tenant then has to ask the court for that sort of order, that sort of relief, and provide proof as to why they need that relief. And then the court would have the authority to issue that order. So it's not just a blanket, everyone's got to reduce the rent by 25% over the next 12 months. It's in that particular circumstance. But again, I'm holding out hope that we don't really have to face this at any point in the future. But it is something to keep an eye on.
Do you have a suggestion on how to handle rent deferral discussions versus reduction, and how to document that with a tenant?
Yeah, so I'm telling clients, when someone comes forward and says, "Hey, I can't pay the rent due to the coronavirus," some of the laws allow the landlord to ask the tenant for documentation to establish that, which is fine. But a lot of the jurisdictions are also, it doesn't say the tenant has to provide actual physical documentation. They can just provide information. So, hey, I lost my job. That's probably sufficient. So in a lot of these cases, I'm telling clients, rather than really hounding the tenant for the the information to establish that, because, hey, look, everyone's been impacted by this. Everyone in the world virtually has been impacted by this in some regard. So really, focusing and responding, okay, so you can't pay the April rent, you can't pay the May rent, whatever it is. How much can you pay? So the key there is trying to get something from the tenant, so sort of put the ball back on, their court. How much can you pay? Okay, you can pay half. Well, let's see what sort of terms we can work out for the balance. Now I'm not waiving it, but I am agreeing.
Oh, we lost you. Are you there? Okay. Well, I'm going to, Tim, I want to ask you, are there new forms of liability that you're seeing related to COVID that you're having to deal with? Like, oh, sorry, Steve, we lost you.
Oh, yeah.
Yeah,
So,
but go ahead, finish up there.
yes, you can't force the tenant to sign anything, but what I'm seeing is if you are, sympathetic and, look, we're in this together, and try to work with the tenant, the tenants have generally been somewhat accommodating.
Okay. All right. Tim, I was going to ask you, are there new forms of liability you're seeing around COVID? I mean, in the press, we've seen the restaurants saying, okay, am I covered? Is this harmful to my business? But is it anything new you're seeing, and what wouldn't you cover?
Well, there's a couple of things that are making the highlights. Some of the people are on the radio talking about it and things like that. You're hearing a lot of business interruption coverage, and that's where the lawsuits are being filed. There's a couple of class action lawsuits being filed, one out of New Jersey, one out of Florida, and things like that. And a lot of it has got to deal with, you guys were talking about force majeure a few minutes earlier. What exactly is that, and what is considered an actual government shutdown? Hey, because of the government shutdown, like a civil action is the way it's worded in your insurance policy. And the questions are, does this civil authority or this civil action apply in this particular area? And typically it doesn't. And the reason why is most of the time you're talking about a civil authority is you're talking about the LA riots, or you're talking about the Watts riots, or you're talking about things of that nature where there's actual civil action. And at the end of the day, it boils down to a couple of things. The way the wording of the policy is, it talks about what's the trigger. Is there a bodily injury or is there physical damage? And the question is whether or not the coronavirus actually causes a physical damage to the location where you're having to shut down. And the liability lays in the wording of the policy. And in the policy, there's actually policy language, because although it wasn't to this extent, what you had when SARS and MERS first came out is that you had people not coming into work because of it. And after those situations happened, wording actually was put into the policies that specifically excluded viruses of this nature. And they're in almost every policy language, specifically because of SARS. And if you look at the actual name of the coronavirus, it starts with SARS, and South Asian Respiratory, whatever the S stands for, I can't remember. But they put that language in. And now what you're starting to see, and Lloyd's has been on the forefront of this business interruption class action suit, the new policy language coming out from some of the carriers, including Lloyd's, is that all your new policies will have this pandemic coronavirus type language in it, specifically excluding it across the entire land of the policy. So you're starting to see more restrictions on it. But right now, for the most part, most of these claims are going to be denied because of the policy language.
Okay. Well, here's a great question. Thanks for that, Tim. We had a signed contract with a company to buy our hemp farm and business. They extended the deadline of 1 week to sign off on the due diligence. Then they backed out and blamed it on the virus. In the meantime, they entered into another purchase agreement with another farm. They'd given us a $300,000 advance payment and want it back. Our contract has a force majeure clause. We don't want to pay it back or delay it as long as possible. We want to claim coronavirus issues. Can we do that? How do you tackle that issue?
That's a David issue.
I'll turn my microphone back on.
There you go.
It all depends on the language of the contract and language regarding deposits, whether or not deposits are refundable. And really on that force majeure clause, because what the force majeure clause is going to do, it's going to terminate the entire
David, are you
contract.
there? Oh, you froze up a little bit there.
Oh, I did?
Yeah. Maybe go a little, speak a little bit slower.
Oh, okay. All right. So a lot of it is going to depend on what the force majeure language in the contract says and whether or not this is a force majeure type issue that would be contemplated or covered by that contract. Because even if you have a deposit language in the contract that says either all of that $300,000 deposit or a portion of it is non-refundable, a lot of it's going to depend on what that paragraph says and what the force majeure language says, because force majeure will terminate the contract and end it. So that's one of those things where you'd have to really evaluate it based on the facts of the situation. And, unfortunately, most force majeure clauses you have to evaluate it on the facts of the situation. And we're in very unique times with very unique facts. So that's something, and definitely when you're considering $300,000 in a canceled sale of that magnitude, something you should have a professional take a look at and read the language and go over with you and work through a strategy and options.
Got it. Okay. Anyone familiar with the split roll ballot initiative in California? Whose area is that? No? Okay. All right. We got a question on that. I wasn't sure. And then we're getting close here. I've got take one last question here. And well, sort of a follow-up, David, to you and Harry, I might ask you this. In a negotiation like that with this hemp farm, that's a lot of money that's going back and forth.
Yeah.
And if that blows up on somebody, I mean, doesn't that get into making sure you're buttoned up and protected in case people start suing and coming after each other?
Yes, of course. That's an instance where I think on either side of that deal, you're going to want to be as fully asset protected as possible. Plus, you have to consider the nature of the product and the goods that are being sold and transacted. That's a pretty explosive business as it is. And it's something that's new and burgeoning. So I think by all means, you should go through a full asset protection analysis and take whatever steps you can to asset protect yourself before waging war over a contract of that nature. And asset protection honestly starts with the contract. It starts with the deal and the language and what's in there. And having a professional, having an attorney look at it and advise you on what should be in there, what should not, the specifics, and that sort of thing. So you end up with as few questions as possible, in the event that you have to go to war and litigate over a deal like that. The less ambiguity, the less money you're going to spend. If something is ambiguous, if something is fact-driven, it's going to cost you, as Steve can also tell you, it's going to cost you a lot of money to litigate and to work your way through in the end.
Yep. Well, Harry, I want to sign off with you, and maybe you could just give us your best advice for those people who have assets, business, cash, stocks, bonds, rental property. Things are getting frothy out there. What are your parting words that people should be focused on to guard themselves right now?
Well, I thought about that long and hard. As the owner of a law firm and providing a service to all the people that we work with, and for those that we don't work with as of yet. So we could spend the next hour or two or three or four talking about the various specific questions and issues that deal with us as regard to this particular pandemic. But here's the works. We as a firm, and this is not being solicitous, but we as a firm are going to be providing for anybody a complimentary look and review of their estate plan and what steps they have taken so far on asset protection. So during this time, we're going to take a look and at least be able to very quickly let you know where those vulnerabilities will be. And if it was me, and it is me, I would make sure that once the vulnerability is determined, what are my options? What can I do to shore everything up as best as I possibly can? So when and if the impact of this, because it's early yet, the impact of this over the next 12, 18, 24 months comes to land at my door, that we are the best prepared that we possibly can be to survive. I don't think it's any different when dealing with a disease or we're dealing with this. How can we be in the best and strongest position to be able to survive a scenario where, truthfully, everybody is frightened? So, for example, when even you're late a little bit on a line of credit payment, in normal times, they say, oh, no problem, you're a good business, everything will be resolved in 60 days. But now the creditor is much more nervous. The creditor is not sure that you'll be fine 60, 70, 80, 90 days and may bring litigation to protect themselves as early as possible. So we need to do everything we can to bolster ourselves and understand that the volatility of the situation does require that. All right, Paul.
Great. Harry, David.
Great. Thank you.
Yeah, Harry, David, Steve, Tim, thank you so much, panel. Thank you, everybody, for jumping on this episode of Wealth Protector TV. We'll get you out the recording, everything else you need to get the assessment, and we'll hope to see you on the next show. Thanks, everybody.
You got it. Thank you.
All right. Thank you.
Bye.
Thanks, guys.
Thanks, guys.